Liberty Nation with Tim Donner.
Now, finally, you will say, we're not going to talk about the convention in this segment, are we? The Democrats or the Republicans or anything? And the answer is a resounding no, we are not. We have reserved this segment for one of our signature segments here on Liberty Nation Radio, which we entitle Talkin Liberty. It needs no explanation, nor does the man who once again returns to us as LibertyNation.com legal affairs editor, the constitutional lawyer, and the man we like to call our guardian of individual liberty, Scott David Cosenza. Hello, Scott.
With some happy news right up the top
Happy
today.
news about Robert Kraft. Now, my first question...
A couple of good stories today, Tim.
You're going to do the Robert Kraft story, but you need to explain why you're leading with the fact that the owner of the Patriots has basically had something turn his way in a court case that a lot of people care about or not.
Well, we've reported on it for a while now. Robert Kraft won his appeal at the Florida Appeals Court. He has been accused of soliciting prostitution and engaging in prostitution. And the police in Palm Beach County videotaped him in the Orchids of Asia Day Spa, famously. And he's been fighting the production of that videotape in court. So they want to charge him with these crimes and introduce that video against him. And he has said that the way that the tapes were made violated his Fourth Amendment rights, as well as the Fourth Amendment rights of the proprietor of the establishment, the employees, and any other persons who were in the establishment. Okay?
Fourth Amendment being the protection against unreasonable search and seizure.
Exactly. So he won at the trial court level. That court said these tapes were made illegally in violation of the Fourth Amendment rights that he holds. In particular, Tim, it's one of the longstanding ones is the minimization requirement. So it's extraordinary for law enforcement to be able to legally capture audio and or video. And if they do so, they have to do what's called minimize, which is to only look at the stuff that is most likely to be the incriminating evidence that they're looking for. They didn't do that in this case. There was no minimization at all. The police, in fact, ignored the minimization requirement, which is why at the lower court level they threw out the tapes, and why at the appellate court level they also threw out the tapes. In addition, at this intermediate level, one of the three-judge panel, which unanimously agreed that the tapes should be excluded from any evidence, also said that Florida law itself, in other words, not the U.S. constitutional Fourth Amendment protections, but within Florida state statutes, there are additional protections. Apparently, the Florida legislature is not keen on law enforcement using audio or videotape to do prostitution stings. And you might imagine, for a good reason why, right?
Yeah.
Because of the behavior that it might encourage. And so they've actually excluded...
Or expose.
So they've actually excluded or exposed audio tape evidence by name in the statute, and one of the judges said that is also applies to the videotape evidence. So I think while the case itself against Robert Kraft hasn't yet been dismissed, I think it will be in short order without this kind of evidence. That's assuming that an appeal isn't made to the Florida Supreme Court. Dave Arenberg is the Palm Beach County attorney, the prosecutor in this case, who is a Democrat going against Kraft, who is famously chummy with President Trump. Mm-hmm. And, we're going to have to see if he's going to expend more taxpayer resources to go, Tim, for a third bite at the apple to prosecute this misdemeanor prostitution case, which, if we recall, all got started because of allegations of human trafficking, which never appeared and were never charged.
On to California, where a firearm magazine ban has been ruled unconstitutional at the Ninth.
That's why I put it in the title for you.
The Ninth Circuit?
So that you would have
Come
that
on,
reaction.
That's a joke title, right?
So that for people who don't know, the Ninth Circuit, often and derisively called the Ninth Circus, it has the most... it's mostly associated with like the vanguard of leftist legal thought in the appellate courts. It's changing, though, as Donald Trump gets his appointments, and this decision was written by a Trump appointee a Mr. Lee, who happens to be a South Korean immigrant, by the way, who joined up with a Hispanic woman to write for this majority, and in the minority opinion was a white lady, by the way. It's
Good.
kind of funny
Let's apply identity politics right over all of these judges, since it's done with everybody else.
It's interesting. One of the things is where it kind of particularly applies here, Tim, is that Judge Lee crafted his opinion, and he wrote about the minorities and the rights of the minority, both political minorities and also racial and ethnic minorities, and that the state or government often does not protect minorities. And it is the right to keep and bear arms, the right to self-defense that the Second Amendment protects, that they can rely on in times when the government is not protecting them, whether that's systematically or periodically. And so it was, I thought, a rousing and really a welcome opinion. I think that, we've talked before about how the Supreme Court has refused to take any gun cases as of late, and one of the things that can really benefit a movement in terms of constitutional rights is a really good groundwork in the lower courts. And I think Judge Lee's opinion does that, and also he really lays waste to the idea that restricting full-capacity magazines or high-capacity magazines is somehow they're like weapons of or accessories of war, whatever the gun banners try, because of the millions and millions and millions of them that are used, in Americans' homes every day. That it's not some exotic feature, and that they are fundamental protections.
Well, if you add the word assault before any weapon, for all those millions of people that know nothing about guns, it makes them sound more scary, makes it easier for them to support gun control without thinking through the whole process. All right, let's stay.
By the way, we might see en banc review on that because it was a three-judge, and then, obviously potential for Supreme Court review as well.
Now, the Ninth Circuit obviously has changed somewhat, but has it changed enough that this particular pro-conservative decision, as it were, would stand the test of the entire Ninth Circuit en banc, as you say?
Well, because the Ninth Circuit is the largest of the circuit courts, it doesn't have a true en banc setting like all of the others do. It's unique in this regard. In all the other ones, the entirety of the circuit will sit in an en banc review, at least those judges who aren't on senior status. But because the Ninth Circuit has so many judges, they don't do it that way. They make a selection of, I don't know, I think it might be like a dozen or 10. Actually, I'm sure it makes sense that it would be an odd number, right? So
I would
perhaps that's it. But in any case, it's much less than the entire circuit that sit. And I believe it's like a lottery type system. So depending on who the judges are, they certainly do not assign those judges based on the president that appointed them to the circuit, Tim. I know that for sure.
Oh, certainly. Well, Chief Justice Roberts told us that. He said there's no Obama judges or Trump judges. There's only fair-minded judges. Now let's stay in California, and we go to Oakland, where the fired police chief is filing a whistleblower lawsuit against the city. How come?
I thought this was a really fascinating story. The chief's name is Anna Kilpatrick, and she talks about how the Oversight Commission, the Civilian Oversight Review Board, was rife with its own corruption. And I just thought it was an interesting story because it's like, well, who's watching the watchers is always the thing, right?
Yeah.
And I don't know how you correct for this, but basically she says that these civilians, anything you can imagine in terms of improper special treatment is what they wanted. So if they wanted to get out of stuff, if they got a ticket, they wanted to get out of jail free card. And if there was some noisy neighbors, they wanted more police presence in their area. They were pestering the cops like they were their, they were like stockholders in the police corporation rather than, oversight members. And so I just thought it was interesting that no matter what we do in a society to kind of put controls on the police and the governed, there has to be some control always on the controllers, or else because you'll just see that power accrues to corruption usually.
All right, the cop who allegedly kneed a subdued suspect in the eye 20 to 30 times gets qualified immunity, and this is a huge issue in police reform, Scott.
I just
qualified
think we should
immunity.
talk about these qualified immunity cases from time to time. It's shocking how often they do come up, Tim, and I think that perhaps one of the best things that could come out of the Black Lives Matter movement and the protests in the wake of the George Floyd killing is real reform of qualified immunity. We now have a situation where, like you say, this is a subdued suspect who was kneed in their eye 20 to 30 times.
It's just. I guess it was. Was it not on video, so we can't see it?
They did it. They did it. But that's the madness that is qualified immunity. In other words, because a previous suspect hadn't been assaulted in the same manner by the police officer, that means that this victim can't succeed with their lawsuit. That's what qualified immunity means. And it is a judge-made doctrine. This is not something that our legislature has weighed in on or the executive. It's just a judge-made doctrine that has modified the immunity standards allowed in law. And I think that we can all agree that it's not okay when a suspect is handcuffed to knee them in the eye 20 to 30 times and then have no recourse at civil law for the suspect.
Well, qualified immunity is one of those things that most people believe, majority of people believe needs reform. And of course, there's the national database of police misconduct that everybody also agrees is necessary to rein in this problem with police. Thank you, Scott.
Thanks, Tim.